Well, hello everyone, and thank you for joining us again, and welcome to our co-parenting and coffee event. Today's theme is prepping for court with Talking Parents. And today we have divorce and child custody attorney Carina Reyna here with us to discuss this important family law topic. Welcome, Carina.
Hi, good morning.
Carina is the founder and managing partner of Reyna Law, a professional corporation. She was also named Super Lawyers Rising Star in 2024 and one of Los Angeles' top divorce and family law attorneys for 2020, 2021, and 2022. Her passion for family law has helped countless parents navigate through the difficult process of divorce and custody matters. Thank you so much for being here with us, Carina. This morning we're here to talk about how co-parents can utilize Talking Parents, the app, in their preparation for court, including maybe some tips on what to document and how they should document it, some example stipulations that they might want to request, and the best ways to work with an attorney and with the court system to support your case, and so much more. And of course, we're going to also open up for questions. I'm sure we'll have lots of questions today that we want to open up for people. But if that's okay with you, I would like to just go ahead and jump right into our first question.
Yeah, let's go for it.
Excellent. Well, as we know, documentation is so important, right? For custody-related court cases. But sometimes I think it's hard for us to know what all to keep track of or what might come in handy down the road. You know, you've got the filing cabinet that's got the user manual to a kettle that you bought 16 years ago. How much stuff are you supposed to hang on to, and what can you get rid of? What sorts of information, interactions do you recommend keeping track of in a co-parenting situation?
Well, every case is very different, right? And every co-parent is different. The main things that courts tend to look at is if the other party is late, consistently late, like, right, not one or two times late, unresponsiveness, if they don't share certain events that are occurring at their home, maybe the child fell and they don't bring it to your attention first, the fact that they don't attend school events or doctor's appointments. This is why it's important to always just document everything. For example, if you want to document that someone is consistently late, you would go into the app after drop off and state, hey, I just wanted to bring it to your attention that you were 6 minutes late. You were also late last week. If there's an issue, please let me know in the future so that we can try to adjust the time. That way you sound like a great co-parent, but you're also documenting it for the court, which is going to come a long way if the tardiness continues.
Okay, so understood. So what we're saying there is in that situation, you would actually message the other co-parent, and now that the message has gone through, that means it's now in writing so that it will be available to the court. But not only is it like a little note to self, it's actually proving a little bit of your parenting method and trying to demonstrate where you are taking responsibility. Does that sound like a good assessment of what you said?
Yes, and sometimes the co-parent will do it themselves, right? They'll say running a little late, and then you can say okay. Or if it's curbside pickup, meaning that they are going to pick up the child outside and not come to the door, they may text with "I'm here." This is all great because it documents the fact that they were late. But it's important to go in and document it yourself if you don't have that, because it's just a way of having everything. For example, I had a case where my client, who was mom in this case, was telling me that the guy was consistently late and that she always had to adjust her schedule. But we're talking like 2-3 hours late. So we went in and we searched the word late throughout the Talking Parents PDF document that was sent to me. And we realized that he was late every Wednesday. So for us, that meant that we went into court and stated that he obviously would not be able to have appropriate parenting time on Wednesdays because he was consistently late 2 to 3 hours, which is not okay.
So that makes a really compelling case then to document every single time, if for no other reason than establishing the patterns of behavior, right? Because if we just sporadically document when things happen, it's hard to build a more complete story from that.
Yes, and you wouldn't be able to figure out that he is or she is late every Wednesday, or that something happens every Thursday. For example, if your child comes home every Thursday with a scratch or something, you can go in there and state what's happening. He's coming home with a scratch or with a mark. Maybe he's just being taken to the park on Thursdays, and then you just kind of know, okay, he goes to the park where he's going to come home with his knee scratched. But you wouldn't be able to figure out the like the dates or things, a timeline, if you didn't have it all on one document.
Wow. Okay. Those are fantastic examples, especially on punctuality. But you mentioned a few other things. You said one that surprised me a little. You said failing to or neglecting to mention significant events that had happened while staying with the other co-parent. What would that look like?
So, for example, if you had to take your child to the doctor, you should always notate it on Talking Parents. You should always indicate on there whether it was, just for a checkup, or if something was happening and you had to take them to urgent care, the emergency room. It has to be documented. The issue comes in is when during exchanges, mother will hand father a a doctor's summary report and say, here, I took him to the doctor last Tuesday. Well, in that case, you would go on Talking Parents, and dad would say, thank you for providing me with the summary report. However, you should have let me know beforehand whether it was a routine checkup. That way I could have opted to be there as well. I could have taken our child since you took him to the doctor last visit. Or, if it was an emergency or urgent care visit, I should be up to date and I should know as soon as reasonably possible, right? If it's an emergency and you're rushing your child to the emergency room, you're not going to think to text someone or to go on the app. But as soon as it's reasonably possible, you should, not a week later or 3 days
Yep.
later during an exchange.
That's really good insight, because what makes it important then to understand and to learn this list of things that are important to document is not just so that we know when it's on us to document those things, but also when our co-parent has not documented those, that is the time to get the documentation in, even though it's coming from my side of the story now, correct?
Correct. I think that that's where you need to use Talking Parents to your advantage. And I tell clients, it might make you sound crazy since you're going in there and saying, hey, I understand you were late again, or next time our child doesn't do their homework, can you please let me know so that I know what I'm supposed to work on? Things like that, make you sound like you're repeating yourself,
Mm-hmm.
or it makes you sound like, you're telling him he's not or she's not doing their part. But in the end, it helps you just keep track of everything going on, because then when it comes time to your case or time for court, you can just search certain words like late. You can search words like homework, and it'll come up to show what you guys talked about every time you mention.
Mm.
And it may be that on Mondays, your child came home from weekends with him without any homework done. And then you can establish that pattern. I think that most people don't realize that those things are huge for court. Um, People are just trying to look at when the other parent is rude to them, or frustrates
Right.
them, or belittles them, or is constantly harassing them or questioning them on things. Um, but and and that may come into play too, but I think those other little details, because they are about the child, those mean a lot to the court. And if you can build a case on those using the app and the tools that are available to you, I think that you'd have such a great advantage in court.
That's really good, and I think it's easy when we're in the app to think of it as we're just messaging back and forth. This is just a conversation. It's a text message thread, but in reality, we need to think of this as a logbook of events, of all of the events that are happening, and they're getting a little timestamp on every single one of those pieces of communication. And you listed so many great examples there, so especially documenting things like punctuality issues or neglecting to inform of significant issues that pop up. What are that would be putting it, as we talked about right now, in the conversation thread. But what are some other features in like the Talking Parents app or other ways you could use the Talking Parents service that could help you organize and record your documentation?
Well, there's so many features. There is the messaging records, right? They can't be altered. There's also the calling feature. The court may order that the parents have a 7 p.m. Call with the minor child. It would either show that one parent did not pick up the phone during that time for the call, or that the parent didn't actually call. For example, I had one case where dad kept claiming he wasn't calling because mom had him blocked. Well, there's no way to block someone on Talking Parents. So I
Right.
think that if they had the feature at that time, that would have never been an issue. And she didn't have him blocked, but how do we prove that he was just not calling? So ultimately, I just told her, just call him and screenshot it, and then put it on your Talking Parents if you need to. And I think this was before they got really comfortable with using the calling feature. But
Yep.
once they used the calling feature, it got rid of those little issues. The other thing would be the accounts and payments. It would be a very good way of keeping track of those. The shared calendar, those are really important, because someone can't claim that they didn't know about a certain activity, school event, because it's in the shared calendar. When something is in the shared calendar, you no longer have to remind that party, right? Because it's in
Right.
there. You already put it in there. A lot of people tell me that they feel like they have to constantly remind the other party about what their child is doing. Like, don't forget that, they have recital coming up next Monday. Well, if you put things in the calendar, you wouldn't have to do it. But I would always still encourage you to do it, because having both parents at an event for a child is in their best interest, and things come up, right? But if you're looking at it like this person is claiming they want to be a part of their child, but they're not, or child's education or activities, but they're not actually making the effort to be there, that's a good way of showing that.
That's really good. And I love what you said is it comes back to what's in the child's best interest. And I know we were even talking a little off camera earlier about how emotional it can get, and how in the heat of the moment
Yes.
as the conversation is going back and forth, but ultimately it still keeps coming back down to what is most beneficial for the child. So the shared calendar, the accountable calling, the secure messaging, these are all features that are part of this holistic record, this log that is building a picture for the attorney and for the court system, correct? Of what has been
Yes.
happening and how the relationship has progressed. What about the personal journal feature in the Talking Parents app? Is that also part of the record that people could use?
I think the personal journal is more to keep track of things that occur for yourself, because I think that after months, it's easy to forget little things that have occurred, because you
Mm,
tend to remember the bigger events, or the most recent events. I think it would be a feature that's easier for you to go back in and check the messages and remind yourself of where they're at. I don't
yeah,
think that the journal would be something that I would ever present into evidence, because it's your diary, right? Like your
yeah,
journal. It would be what you were feeling, what you were thinking at the time. And it may have nothing to do with what actually really occurred,
that makes
because certain
sense.
things, trigger people in a certain way that wouldn't normally trigger other people. But I think
Yeah,
it is a good place to have everything, right? So instead of
right.
writing it down in your notes on your phone, if you write it down in Talking Parents, it'll always be there. So if you got a new phone, and an update happened, and all of a sudden we don't have our notes on our phone that many people use a lot,
Yeah.
you would still have those on Talking Parents.
Oh, that's really good advice. And of course, there's the accountable payments, as you mentioned, which is also part of the record of the nature of the relationship, of the nature of the communication between the two co-parents, right? As even just being able to
Yes.
keep a history of that log as well. Well, with Talking Parents keeping all of these records, they are unalterable. So you can't go back in and edit it. You can't go in and delete something you may have said. And all of these interactions take place in the service, from messages and calls, calendars and payments. For you working as an attorney, working with your clients, how do these records help co-parents work with you, and how do they help co-parents work with the court system?
Well, it definitely makes it easier to gather evidence to use in court, because most of the time, the court is not going to question the talking parents transcript because, the messages can't be altered. So it makes it easier to gather the evidence. It makes it easier to present the evidence, whether we're presenting just a conversation that took place on a particular day or whether we're printing out the entire talking parents transcripts and submitting it to the court. It's also easy for the court to follow along with the message because a lot of times if you have a conversation on your cell phone, you're taking a bunch of screenshots of the message, which may not capture the message as it actually happened. So in Talking Parents, you leave everything in chronological order and you can go through it precisely and see where everything falls and how the conversation goes. As an attorney, I think it's important to go through these talking parent messages. And I know a lot of attorneys don't naturally do it, especially when they think that their client is a normal, reasonable person. But as you said, in this type of situations, emotions get the best of us sometimes, even if you think that you're not an emotional person. So what I do is sporadically, I'll just say, if things are coming up, can you just send me your talking parents transcripts? I'm just going to kind of go through them. And I'm not necessarily going through what the other parent said. I want to just see how my client responds and whether I need to have him or her adjust their responses. So if I notice that my client's responses are a paragraph long, I'm going to get on the phone and say, you're no longer talking about the child if you're sending a paragraph thing. It's just, you're not. I'm going to make sure that they get to the point and make it short and sweet because that makes it easier for a judge to read. So whether it's, our child has a recital, here's the date and time, you don't have to give out all of the information about the recital or give your opinion as to why they should be at a recital or shouldn't be at a recital.
Right.
So sometimes it's just important to look at those messages as an attorney to make sure that you're not surprised in court to find out that your party is the person that's actually sending the harassing messages. And it may not be in a bad way. It may just be that they're constantly messaging about the children, which is borderline harassment in a way, because you shouldn't be messaging about the children every day unless things are happening every day. It should be whenever things are actually coming up.
So I guess then a lot of what happens is a lot of he said, she said, and I'm guessing
Yes.
that you've experienced and even encountered where people have tried to falsify records or falsify documentation
Yes.
and submit it, right, as evidence. Has that been a thing that has happened, that Talking Parents has been able to reduce some of that?
Yes, definitely. Because, if somebody were to object to a talking parents transcripts, it would be easy to lay the foundation and just have your client say, yes, that's my talking parents conversation that I had with the other parent that I printed out for court. But when it comes to other messages, it does paint the picture of, can those be altered? Are those messages altered? Have they been altered? So recently I had a case where before the parties were using talking parents, they were messaging each other, and we submitted a message to try to show that the other party was doing something that they shouldn't have been doing. And the other party was saying that the message never existed. It wasn't on their phone. So in that case, the judge actually asked my client for their phone and scrolled through to make sure that the message was in line, that the message was sent to the other party. The judge verified their phone number, their name, and it matched. So that's how we were able to get that message in. But with a talking parents transcript, we wouldn't have needed to do all of that. It would have just been there. In fact, there's been plenty of times where the other party is saying, oh, I said this, I didn't say this, I told them. And then I will actually read a message from them in court out loud stating, well, you did tell them, but you also told them that you weren't going to provide her or him with a soccer schedule, or that you weren't going to list them as the emergency contact. So it's just nice to be able to have it there at your convenience in court, to be able to submit to court prior to your hearing, or just to be able to have dramatic effects during the hearing, like reading it directly.
Well, and this could be a huge saving grace then, because you're not having to hope to convince a judge or a court, or try to twist somebody's arm into seeing your side of a story, or trying to
Hmm.
assume that somebody's going to get some context in there. Instead, by using these services, especially that secure messaging part of the app that you were talking about, of just every time there's something that's documentable or noteworthy, you message it to the other co-parent. I like your idea of short, concise messages as well. I would have thought the same thing. I would have thought, I'm defending my case, I gotta do a long story in here. But it makes a lot more sense that you said, who's going to read through that? It's not going to help your case. That's
No.
really, really interesting. This has been such great advice. I wanted to talk about co-parents who might be having a hard time getting the other parent to communicate with them through Talking Parents, or perhaps their other co-parent isn't responding to messages or requests in a timely manner. Are there stipulations, or are there parameters that co-parents can have put in place to help with this by working with their attorney, or maybe working with the court system to sort of enforce some sort of behavior in there?
Yes, there is. Usually by now, most courts, and I'm reluctant to say every court, because I do think that every court, every family law court, will include a stipulation to use Talking Parents or a court appointed app.
Mm.
Um, and what they indicate is that all communications shall be on Talking Parents, except for the case of an emergency, right? Because if there's an emergency and you're on your way to the ER, you should not put it on Talking Parents and wait for them to respond. You should
Right.
probably pick up the phone and call the other party. So it would be all communications should be on Talking Parents, except for in the case of the emergency, all communications must be about the minor children. So we don't
Mm.
want to hear about how you acted last year on this person's birthday, or how you were towards this person's mother. Those were not things that should be on Talking Parents. It should be exclusively about the children. A lot of people get caught up on Talking Parents talking about other things. So the
Mm.
court makes it very specific and tailored to the children. If that's not a stipulation that the court has given you and the other parent, I think that that's something that you should definitely ask for in court if you're not represented, or speak to your attorney about getting both of you guys on Talking Parents if you are represented. And the other thing that the court does is that messages is they state that messages should be responded within 24 hours.
Ah.
So that's where unresponsiveness comes in. So if you're constantly messaging the other party and they're just simply not responding, it's your way of showing the court that they're just not engaging. They come into court claiming they want to be a part of the child's life, but they don't want to do the work to learn to co-parent with the other party. And how do you learn to co-parent with the other party? You constantly have communications on this platform that are healthy communications about the child, and you guys are able to work through things. And I don't think that people realize that that's how you get to being good co-parents, is by learning to effectively communicate. And Talking Parents is the best tool to help you stay on track about the children and to be able to respond. If you're a parent that's not responding and there's a stipulation in place that you must respond within 24 hours, I think that that's something that's absolutely going to come up in court.
Okay. Curious about, what about the other direction? What if somebody is messaging too much, or if they're blowing up the app constantly? Is that something that could be something that a court could address as a stipulation?
Yes, absolutely. And I actually just recently had that come up in a case where the parties were ordered to utilize Talking Parents, and the other party was utilizing Talking Parents as a form to continue harassing my client. So they were sending, and the harassment is a there's different layers of harassment, right? So it may not be as drastic, but in this case, they were sending over 90 messages a day. There's no way that
Hmm.
you're talking to your co-parent about the child and it needs to be over 90 messages a day. So in this case, the court indicated that each party is limited to only one message per day. And the court indicated on there that you better make sure that you say everything that you need to say about the children in that one message, because you only get one message. And that was really important, because In my client's case, she was very adamant about having to check her talking parent messages because she wants to make sure that she's up to date with anything that's happening with the children. But it made it very difficult for her to figure out what was about the children and what was not about the children and more towards her as a person, and more about their divorce and not about the children. So in that case, and I'm assuming it could happen and it happens a lot, the court did limit the communications, not just about the children, but limited the amount of communications that the parties may have to alleviate this harassment or this type of behavior.
That's really good. So that's definitely something that talking parents users should work with their attorneys, work with the court system to figure out how they can even use the app to help enforce some of the better behaviors that we need. Again, because it comes back to what's the most beneficial for our children, right? That's so
Yes,
good.
and it's important to be able to use to use the app the right way. So what I tell clients is that getting on the app will definitely help your children, and it'll help you either learn to be a good co-parent and help your relationship with the other co-parent, or it's going to help your case because the other parent is not going to be able to help themselves and is going to show their true colors, and it'll be something easy for us to show the court. But most of the time people realize that they are on a court appointed app, and they will learn ultimately how to be good co-parents and how to communicate effectively. So it's a win-win situation.
That's so good. I've got so many questions that are coming in from the wonderful viewers who are watching right now and who are, I'm sure, hanging on every word like I am. The question I have for you, we've talked about it, is what's the most beneficial for the child? In what ways are these beneficial? Could using Talking Parents, could it expedite processes? Could it help save money for people going through these costly court cases?
Yes, I definitely think that talking parents can help save money. For one, you don't have to go through the lengthy process of trying to determine that these messages were not altered and that they should be admitted and they're not, fake messages being submitted into the court. But there's also the idea that you're communicating with your co-parent, so you're able to figure out what works. For example, in a certain scenario, you can say, look, I noticed that that you're late to pick up the child on Wednesdays and they have practice. Do you want me to take the child to practice and then you can just pick them up from practice? And those are good ways to be able to help not only your child get to practice on time, but to be able to help your schedule so that one parent is not frustrated with the other parent. There's also just ways to communicate. We have an upcoming court hearing. We didn't get anywhere at mediation. I've thought about it, and I think that this would be a good schedule for us. What do you think? And then at that point, you're opening the platform for the other party to be able to provide you their feedback on talking parents on that schedule. It would also help in court if they're claiming that they have done everything possible to talk to you about adjusting the schedule. And then you can show, look, I just recently indicated to them that I was open to discuss it, not here in court. We could have discussed it before, but they were not open to doing that. And I think that a lot of the times cases have been settled on talking parents, even cases where you would not have ever thought that these people would come to an agreement, because after so much time of working together, being able to communicate effectively, they have learned what schedule is going to be in their children's best interest. They've gotten away from, I absolutely want this day, or I absolutely need this time, and more on the lines of like, okay, this is what's going to work for all of us. And it really is about everyone, obviously highlighting the child and their best interest, but we need to be able to have some flexibility with work schedules and with pickup and drop-offs. And I think that talking parents is the best way to show that.
Oh, that's so good. Thank you so much. I can't tell you how much we appreciate your wisdom on this. We've got so many questions coming in, and right away, one that jumped out to me, and I think this is just gonna tap into your experience here, but what kind of behavior patterns are frowned upon by judges typically?
Well, obviously, like I said before, every case is different, but I think that promptness is a big thing. So if your co-parent is constantly late, not doing homework, tardy to school, not just tardy for pickup and drop offs, tardy to school, um, or if they are turning the conversation into a conversation that's about you two. So when you say, are you going to be able to pick up the child on Wednesday? I know that it's not your day, but I think that you had asked for a Wednesday and what time would be good for you. And then they go into a rant about other things instead of just saying, you know what, I was thinking 3 o'clock is good. Is that good for you? I think those are good ways of showing the court that you're trying to co-parent and they are not. Because if you can show the court that the other side is unable to co-parent with you, again, that's something that they completely look for, and that's something that'll ultimately help your case, because they want to know who is going to be the most reasonable parent, who is going to be the parent that's going to provide the other parent with the information that they need, that's going to put the interests of the children before theirs, and communicate effectively with the co-parent, especially in light of a heated contested divorce going on at the same time in the background, right?
Yeah.
Or other things happening that are not on Talking Parents.
So I guess because the court doesn't have a periscope to look into someone else's life and see what's happening, but that actually can be to your favor in that all the court can see is what you document, and you're responsible for at least 50% of that, right? And so if you can show
Yes.
yourself and show your behavior to be responsible through there, that's
Yes.
gonna help. This next question is quite an interesting one, and I'm not sure where this one goes, but is there a way to show that the other co-parent is having others write for them in the app? And I guess that means they're seeing, hey, this is not what my ex sounds like, or this is not how the conversation was going in every other instance up until now, and all of a sudden it's become very erudite and spell corrected, and as opposed to previously. How can you show that, or what should someone do in a situation where they suspect that's happening?
I think it's hard to really show that unless you document it. So if you're having a conversation with your co-parent and throughout the day they sound a certain way, or their messages are short and to the point, or they're very direct, or they throw in some jabs at you, but then at 6 o'clock, when you know that they're home with their new significant other, all of a sudden the messages change. I think that that's where you can just document, hey, I've noticed that your messages are a little different in the evenings. I understand that you have a new significant other, but this app is supposed to be for you and I. Obviously, the other parent is likely going to deny it. I don't think that it's something that you need to run to court with and say, they're having other people message me, unless it's going to be messages of harassment or issues that are coming up. For example, if throughout the day you're on good terms with your co-parent and you guys are working through everything, but then in the evenings when you know that they are with their significant others, or on the weekends, now they become very hostile or very short-tempered or are attacking you. I would argue that that's not your co-parent, and I would put that on Talking Parents, because it's just you documenting. It's just you putting them on notice. I've noticed this and it should stop. If they don't deny it, then definitely bring it up to the court if it's something that is not beneficial to your child. So if it's just that their tone sounds different, but they're still working through it with you and you just know that it's not them typing it, I don't think that the court really is going to weigh too heavily on that. But again, every case is different, so I wouldn't know when to bring it up or when to not bring it up. It would just depend on how it's done.
But your advice is the same, and that is to, if you suspect something, if you're concerned about something, message your co-parent about that with your concern cleanly and plainly in the app, and then rely on even some of the metadata, the timestamps or the patterns that seem to emerge from it to help tell that story too. Well, that actually leads right into another question on a similar line here. Our viewer said, my daughter started calling her dad's new girlfriend mommy. This started about 2 months ago. There wasn't a conversation between my ex about it, and they adamantly suggest a 6-year-old have freedom to call the girlfriend mommy, which they express with my daughter on FaceTime calls. They've only been together for less than 2 years. How would you use Talking Parents to document this? Would you suggest the calling feature as well to record those calls?
Definitely. I would definitely suggest the calling feature so that the calls are recorded so that there's a transcript of the call. But I would have a conversation with your co-parent about the importance of not having the other child call somebody else mommy or daddy. For example, I've had a case where the my client was not okay with the child calling the stepfather daddy, and he said, would you mind if he is just daddy, insert name Ray or something, right? So
Mhm.
Daddy Ray. Or I had another case where I said, if he wants to call your wife mommy or mama or something, why don't you guys get creative with it and just call her mama bear? Kids are going to run with whatever it is that you're telling them. I don't think that courts are on the same page throughout every family law courtroom on whether or not it's okay to have a child call your significant other mommy or daddy. But I think that if you're going to bring it to your co-parents' attention and they're just going to be dismissive, I think that will go a long way with the court, because you can suggest things like, can she please call her, mama or mama bear or mommy Kathy or whatever it is. It's important to bring suggestions rather than just say, do not ever do it again. Because I think that's just arguing back and forth. And it's not really you saying, hey, I would prefer if we just had one mommy, daddy. And then as we introduce significant others, they become mama this, mama that, daddy, or whatever you want to nickname them.
So how do you feel about parents making agreements through the app in Talking Parents itself? Is that an acceptable thing to do?
I think it definitely is an acceptable thing to do. I think that a court actually will make orders indicating that there are stipulations in place that
Mm.
will protect parties and their communications on Talking Parents. So you can have an agreement, for example, like to change the schedule. You can say, this week I'm picking up on Thursday, dropping off on Friday, even though my schedule is from Wednesday to Thursday. So now, it's on Talking Parents. It's an agreement, and you can put the time for pickup, time for drop off, and if they're late, you would obviously be able to notate that because that was an agreement that you guys made, and it's on there. And I believe that the court will accept those agreements as you guys changing the orders for a specific time, or
Hmm.
whether you're saying, when Sunday drop-offs aren't going to work for me anymore because I go into work later, can I drop off the child earlier? If that's the agreement you guys have, that's going to be the status quo now. When you guys come into court, you can say, we had an agreement that he's going to drop off the child earlier. I think it comes into play when one party says, well, now they're trying to drop off the child to me earlier. Well, yes, but I talked to her about it. I could have easily had childcare for my child and had somebody watch them until 8. But why would I do that when I contacted her and she said it was fine? If she had an issue, she could have said, I'm not available until this time, and we could have discussed it. And that's what the app is for. But that wasn't done.
Got you. But the fact that you make an agreement in the app and then you can show evidence of sticking to it, that's actually going to hold a lot of weight, you're saying, to
Absolutely.
present your case. That's really good. This is a good technical question for you. Is it okay to just cancel a visit on a shared calendar to show that my son didn't go with his dad this weekend? I'm having a hard time encouraging my son to keep his visit with his dad. He doesn't want to go. He's 15. He gets sad every time he has to go. So when his dad doesn't come, then I just cancel on the calendar to show the pattern. Do I still have to put in writing and sending a message stating that he didn't go?
Yes, I would definitely encourage you to put it in writing, because for the calendar, I'm not sure how the court will see that. I mean, they may take it into account and allow you to submit it as evidence. But what if the other party says, no, I did pick him up, and I don't know why the message was canceled. I just didn't go in there and fix it. I think that that's a lot different than putting on the Talking Parent messaging app and stating, our son obviously didn't want to go with you again today. I will do my best to speak with him all week about going with you. Would you like to try to have a conversation with him this week? Maybe to encourage him. I think that that goes a long way because one, you're documenting the fact that the child didn't want to go. And I think that you're trying to figure out ways to show the court that you're not the one holding back your child, that you're trying to come up with resolutions, that you're telling dad that you're going to do whatever possible to encourage their son to go. And you're finding alternatives for dad, right? Would you like to FaceTime him in a little while instead? I think that that goes a long way because if dad comes into court stating our son doesn't want to go because mom is alienating, mom is saying, trying to tell him he can't go or making him feel bad about going, you can say, well, that's not true because when I've told him this, he, doesn't tell me that on Talking Parents and he will just refuse to FaceTime. I don't think that the court will take that lightly if you were trying to facilitate additional time with dad or you're trying to make an effort and it's on Talking Parents. I think that that's the best way to go.
Yeah, if I could summarize something I think I've really picked up today is try to leave as little as possible for the court to try to infer. So rather than just removing a calendar appointment, instead explicitly state in the communication thread specifically what happened and why. And I love your idea of always providing or proffering suggestions or alternatives so that it's not a hard no shutting somebody down, but instead showing I want to be reasonable about this thing. But then, yes, like you said, so don't let them, it shouldn't be implied that they're not picking up because they're not showing up. Instead, it should be explicitly stated in there so that there's a nice history of this going along behind. This is a tough one. This viewer asked, what if a judge states they cannot be bothered to read a troubling or abusive conversation initiated by one of the parents? What do we do in a situation like that?
I think that in those kind of situations, something must have happened already that the court may be just frustrated with both parties. Maybe both parties are continuing to point fingers at each other. Maybe the court already realized that it's not just one party that's being the hostile parent, it's both. So in that sense, the court may look or may think, why am I going to continue reading all of this if it's both of you? And that's really important because I think that co-parenting doesn't come naturally to people. And I say this all the time. It really doesn't. It's hard, especially when you're in the middle of a separation and your feelings are still very hurt. It is difficult to co-parent and sometimes it takes work to get you to that place. But it's important for you to work on it yourself for your child instead of you thinking, well, if they are being, this way, then I need to do it this way because I need to protect myself. Well, no, you're no longer in a relationship with that person. You don't need to protect yourself or your image or whatever it is that they think about you. They can think whatever. You just need to do what's in your child's best interest. And right now, that is having a good co-parenting relationship with them. So when a judge is just dismissing or no longer wants to read it, I think it is because they think that it's a little bit of both parents and they would likely suggest that the parties attend some high conflict co-parenting classes or that the messages it will be limited to only about the children. So it will ultimately teach the parties to not have this back and forth, he said, she said.
And we've done some of those high conflict co-parenting conversations here at Talking Parents too. We've got two different types of questions coming in here, and it's interesting because we got some on one side who are saying I need the other party to interact more, and some actually are saying I need the other party to interact less. But let me start with the interact more here, where someone is asking, I'm still using Talking Parents, but what if my son's father has stopped using Talking Parents? And another question very similar to this was, how do I show to the court that the other parent is unwilling to co-parent effectively with me?
Well, I think it would be the same thing as I stated, that you have to document everything, right? You continue using Talking Parents as ordered by the court. And if they're non-responsive, then you show the court, look at everything. Every time I've messaged dad, I messaged dad about passports, about enrolling into soccer, about school events coming up, about doctor's appointments, about getting immunization shots or whatever that is
Mm-hmm.
coming up for your child, and they've never responded, but they're here in court stating that I'm the problem and that I don't communicate effectively when that's not the case. And the other way of doing that is just to show the court that you are communicating this and that you are the good co-parent and that they are not a good co-parent because they're either non-responsive or they're just responding with okay. I think that it's very difficult to have a good co-parenting relationship with someone that's not going to engage in the conversation. You don't have to
Mm.
completely engage in everything written, but if they indicate, hey, I'm going to take our child to the doctor on Tuesday, it's just going to be a standard checkup or physical or something of that sort, and just wanted to provide you with the information. You don't have to go into like, well, why, what's going to happen. You can just say, okay, just keep me updated if there's anything that I need, and please provide me with the summary report after the visit. The other way that comes up is when parents are not using talking parents.
Mm.
So this comes up when it's ordered, but the other party is still texting on the side using their regular texting feature, right, on your iPhone.
Yeah.
So what I say is that I will tell or the client to go on Talking Parents and say, hi, I read your text message. I just wanted to remind you to use the Talking Parent app, and here's my response to the message. If it continues, I would screenshot the message and put it on Talking Parents and say, hey, again, I am reminding you to use the Talking Parents app. But in the screenshot, I think it's important for you to also have a message on the regular messaging system that's being used, stating, I will respond on Talking Parents. Please use Talking Parents, so that you can show the court that you've been doing
Yeah.
that, and that you're trying to bring that party back in, because it happens a lot. I don't know why parties just sometimes don't want to
Mm-hmm.
use Talking Parents, but that's a good way of showing that they're unwilling to follow the court order, because it's a court order regardless of what you think about it. It's a
Yeah.
court order, which means that if you don't follow this court order, what makes us think you're going to follow the other court orders?
Well, and I like what you said there about if a parent is unwilling, if a co-parent is showing an unwillingness to the court to even use the app for the communication of the co-parenting, it's not showing a very high level of dedication to the co-parenting process. So if a co-parent is refusing to use the app, really just the fact of documenting that in and of itself helps your case is really what we're saying there, right?
Yes, absolutely.
Well, because this next question is a similar one about communication outside of the app. This viewer is asking, the children's school has their own app that has regular communication on events, schedules, and pickup times and days off. You're also able to communicate with individual teachers and principals on it. Do I have to reiterate all that info, or is that a sufficient calendar for the court so I can communicate less with my confrontational co-parent?
I think that one, this comes up a lot because I think that all schools use this app feature, right? Or
Yeah.
have electronic communication. I think it's important for you as a co-parent to say, hey, just a reminder, there's the class app for our child. Have you registered? Did you register? Because events come up. I think I said this before. You want to do what's in your child's best interest. So, do you remind them about a recital? Do you remind them about something that's important to your child? Yes, I would, because again, things happen and sometimes, lives get busy and people may forget, not because they're a bad parent, but because again, life happens. So as a parent, I think that yes, you should remind them of big events. It also makes you look very good because you're reminding them and they're still not showing up, right? So it's kind of putting the second layer on it for the court. Like, they not only should have access to this, but I also reminded them a few days before, so they can't say like, oh, I totally forgot, or whatever happened. I also
Right.
reminded them and they still didn't go, which it doesn't make sense to me, because they're claiming that they're off on Wednesdays and this happened on Wednesday, or that they want more time with the child, but they're not interested in certain things with the child. I think that you don't have to constantly go through everything that's on the app. I think that, you can say, hey, I noticed you do the homework this weekend. If you need, if you want me to help you figure out where the homework is on the app, it's under this tab. So it's like you're telling them, I already told you how to do it. It's there, and now you're not doing it. So you're showing the court that you're able to co-parent by showing them, if you didn't know where it was, here it is, or our child should know where it is if you need, to look through it more. But you're also documenting the fact that they didn't do the homework, documenting the fact that the homework is on this app that he or she should be a part of, and that they're not
Yeah.
engaging or co-parenting.
So finding ways to kind of weave the narrative back into the Talking
Yes.
Parents app, and maybe even, as you said earlier, take some screenshots, even though it's not necessarily, you know, unalterable because it's a screenshot. But even just the fact of putting that into the communication, into the thread, shows that you're being intentional about keeping the communication open and making sure it's still being documented in the app, right?
Yes.
Well, we actually had a question here, and we've talked about a little bit about this, about the abuse that can even happen in the app or the harassment that can happen there. But we had a question asking, is there any monitoring in Talking Parents other than if it is brought into court? For example, my co-parenting partner uses profanity, derogatory statements, and wild accusations and harassment. Is the only time things are noticed if it is brought into court?
I think yes, it will be noted into court because most of the time it's just you and that individual talking, right? You can also bring it to your attorney's attention and they can address it with the other party if they don't have an attorney, or address it with the other party's attorney. Hey, I noticed that your client is sending these messages, and most of the time, if I'm going to refer to Talking Parents, I'm going to attach the Talking Parents transcripts or the messages I'm referring to on the email or the letter, and state that, this is not okay for them to continue doing that. I think that that will also show the court that you tried to stop the communications, stop him or her from being this way, and gave them the ability to just try to work through it and be a good parent outside of court. So now your only source of being able to stop that harassment behavior is to bring them to court. So I think, again, you're kind of, you know, taking steps before you get to court to try to address that behavior. But most of the time, it really is just addressed in court.
Okay. Yep, that's really good. It is important for people, I think, to know that what happens in the app is important once it gets into the courtroom. However, it is still really just the communication between you. We had a good question here, whether you could speak about parental alienation practices, trying to get the child maybe to be a little more elusive and distant with one of the co-parents, but how the app could be used to provide evidence of this behavior in conjunction with conversations we've had with the child or text messages that originated from the child that would show some evidence of the other co-parent trying to disrupt that relationship.
So I think that it's important to document things on the app again. So after your weekend visit, if the child comes home and says, "Well, Daddy doesn't want me to hang out with you," or Daddy says that I'm not allowed to have fun at your house, or whatever the case may be, or that I should live with him, I think it's important for you to go on the app and state, "Hey, our son came home and said this. Please do not involve our child in adult matters. Make sure that everything that you talk to our child is child related, age appropriate. They don't need to know what's going on between you and I." If there's messages from the child, and for example, say you found these messages, you can go on Talking Parents and say, "Hey, I saw messages between you and the child during my custodial time where you're telling him to be defiant with me or my spouse, or you're, making him feel bad for enjoying his time here. I don't think it's appropriate. And I would prefer for you to not do it," so that you're actually documenting it. It's really difficult to go into court and just say they are alienating me, or, she's alienating me. Um, that's why I think it's important to document certain behavior or instances. If the child is not willing to go with you and is making a scene, or is very frustrated during the exchanges, and mom is saying, "See, they don't want to be with you. They don't want to go with you. Look at what's happening. Look at what you're doing." sometimes that happens, and it doesn't mean that the other parent is not a good parent. It means that the child may have some loyalty to one parent, so they just have a lot of feelings there. So what I would do if I was the parent, where they're trying to paint the picture that my child doesn't want to go. If now, once I have my child and they've been with me for some time, if they're having fun and they're smiling, we're joking, I would just send a message on the Talking Parents app like, hey, just want to let you know he's good now. He's eating ice cream. We're doing this. And, a lot of people are like, well, I don't want to give a play-by-play of what I'm doing. Well, you're not. You're documenting the fact that there was this scene that happened during the exchange. I don't know why, but once the child comes with me, we're good and it's fine. So I don't know what's happening there that's making him act this way, but it has nothing to do with me and the way that I'm being with my son. And that's a good way to show that you're being alienated in a way, because what else is there to prove or to show that things are very different in one scenario as to the other scenario?
That's good. So you're actually kind of reinforcing your narrative there, or your side of the situation, by documenting that in the app as well. Now, this is quite an interesting question, because what you had said earlier was, in every instance, even if you're not getting a response on it, you still message the other parent and you say this is what happened, and that way it's going to show up in court. But we've got a question here from someone about setting boundaries there in Talking Parents, and they said the father of my child is a narcissist and uses Talking Parents to harass me, put in writing a false narrative. So they'll post, I do not let him speak to our son, et cetera, et cetera. But so how can I ignore these types of messages so we can continue having a normal life when I'm getting 4 or 5 messages a day that are full of these false accusations? We've had a few of these. So sort of the other side of that, of somebody saying this and this happened in the app, even though that wasn't necessarily what happened. How should someone address that without giving up their life to keep addressing it, 4 or 5 times a day to counter these claims?
So this has come up a lot in my practice, and what I have told my client is one, they have to address it. A lot of people think, well, that's not true. Why am I going to respond? Well, when you don't respond, you're not really telling the court that it wasn't true. So you can't wait until court to tell your side of the story. So one way that I would highly recommend responding is just saying, I don't know where this is coming from, but it's not true. Or, if they're saying like, oh, your son said this and this and this and this about you, what do you have to say for yourself? Like, I can't believe this is happening again. And you can go on there and say, again, please do not question our son about what's going on in my home, as I don't question him what's going on in your home. Let's keep the messages positive moving forward, because I'm trying to do my best to co-parent, or that's the only way that we could ever learn to co-parent together, is if we keep these messages positive. So it's really important to deny them and to bring them back to keep the messages about our child and let's stay positive here. But I had a case where a guy was constantly telling my client all these false statements on Talking Parents and making her seem like the world's worst mom. Like, the child was late to school again today. I can't believe that you have custody if you can't even get her to school on time. And she's like, my child wasn't late. So then all she had to say was, this is not true. If you would like, I could provide you a list from the attendance records to show that she actually wasn't late, or you have access to the app. You're free to get that information. I don't know where you're getting this from. And that's it. And they can go on and on and on, and you don't have to respond to it anymore because you already addressed it. It's not true.
And you can feel safe being candid in the app, knowing that you've got your attorneys and you've got a court that will also be able to jump in and read these conversations. Well, I mean, we've been going for about an hour, and I could probably listen to you for a couple more hours on this. So let me wrap up with one last question, and this is trying to gauge the level of communication that is appropriate, and I'm sure it maybe changes with age and with every situation. But the question is there an expectation that a custodial parent give daily updates for a small child, let's say kindergarten? Like, if the non-custodial parent asks every day which toys or games did he or she play with today, like how much should that be kept up to date to the other co-parent?
I think obviously every scenario is different, right? I had a case where um, dad would message mom almost every day at the exact same time at 3 p.m. every day. Can you send me a picture of our son? And she was just getting frustrated because I mean, for that to happen every day. And she's like, sometimes I'm at work, things are happening. Do I have to respond every day? I would say, no, you don't have to respond every day, but always make sure that you respond within 24 hours. If it is a small child, I think it's important to keep father or mother informed as to milestones, because as a parent, you know that children do different things every day, and that other parent may just be feeling like they're missing out. So,
Mm.
again, it's about every situation, right? If you know that this parent just wants to be a part of it, or you're thinking even that they're just doing them for court, then you should try your best to just keep them involved. You can say, hey, I'm so sorry I didn't message you yesterday, it was a really busy day, but this is everything that, nothing really happened. He did try beans for the first time, or he ate a tortilla and didn't like it. I know that pineapples aren't his thing. So just kind of keep it just light and fresh. And if it's every day, you can constantly say, hey, how about I just get on here, every 2, 3 days and give you kind of some updates, because it's very hard to keep track of things that happen every day since I'm home with the small infant every day and I don't have time to be on my phone. Or maybe if you want to incorporate like some FaceTime call on Wednesday, and then you can chat with, you can see the baby and I can kind of update you. And we can use the call feature on Talking Parents, so the transcript is recorded there for everyone's protection. I think that you can get creative, because if they're not an invested party, they're not going to want to have that FaceTime call. They're going to say, oh, you just don't want to keep me informed. What do you mean I don't want to keep you informed? I just said that every 2, 3 days we can have a FaceTime call so you can see your child, even though they're only 3 months and they can't engage, but I can let you know updates, and we could just chat for 5 minutes.
That's good. Oh, and I love that you masterfully brought it full circle back to what is best for the child, because that's what it keeps coming back to. It's so easy for us, again, in the heat of the moment, in the emotions of everything that's happening, to get waylaid by the communication between the co-parents, and it's easy to forget the key important part is, but what is most beneficial to the child in this situation. Carina, I cannot thank you enough for sharing your knowledge and your experience and your wisdom with us this morning. I know we got a lot of people viewing, and I apologize to anybody if I didn't get to your questions, but we've learned so much already today. Carina, thank you so much. Is there anything else you would like to say to our viewers and to all of our wonderful Talking Parents users?
I just think that it's important to use the Talking Parents app to your advantage. In your case, things come up that may be particular to your case. I think it's important to always keep it light and stay positive. Keep it about the child. And if you do all of those things, I guarantee you that the court is not going to listen to false accusations or negative things that come up in court, because it's easy for you to show that things aren't true.
Mm.
So just remember that in your custody case, it's not about you and that other parent. It's not about why your relationship ended or who did what. It is about your child. And now you are expected to deal with this person until your child is old enough to be able to live on their own or do things on their own. And you guys chose each other to be this child's parents, and now you have to live with that choice and do what's best for your child. And I think that people forget that doing what's best for your child is being a happy parent, is being able to deal with difficult situations, is being able to overcome, big feelings that you have, and learn how to process everything and be just a good co-parent to your other parent.
Ah, that's so good. Again, thank you for your expertise, and I know I and so many other parents are very grateful for you sharing your knowledge and your wisdom with us. Thank you so much.
Thank you.